The Subcommittee on Workforce Protections will come to order. Welcome, everyone. I note that a quorum is present. The subcommittee is meeting today to hear testimony on standing up for workers, preventing wage theft, and recovering stolen wages. This is a hybrid hearing pursuant to House Resolution 8 and the regulations thereto. All microphones, both in the room and on the platform, will be kept muted as a general rule to avoid unnecessary background noise. Members and witnesses will be responsible for unmuting themselves when they're recognized to speak or when they wish to seek recognition. When members wish to speak or seek recognition, they should unmute themselves and allow a pause of 2 seconds to ensure the microphone picks up their speech. I would also ask that members please identify themselves before they speak. Members who are participating in person should not be logged onto the remote platform in order to avoid feedback, echoes, and distortion. Members participating remotely shall be considered present in the proceeding when they are visible on camera, and they shall be considered not present when they are not visible on camera. The only exception to this is if they're experiencing technical difficulty and inform committee staff of such difficulty. If any member experiences difficulty during the hearing, you should stay connected on the platform, make sure you're muted, and then use your phone to immediately call the committee's IT director, whose number was provided in advance. Should the chair need to step away for any reason, another majority member is hereby authorized to assume the gavel in the chair's absence. In order to ensure that the committee's 5-minute rule is adhered to, staff will be keeping track of time using the committee's digital timer on the remote platform. For members participating in person, the timer will be broadcast in the committee room on the television monitor as part of the platform gallery view and visible in its own thumbnail window. The committee room timer will not be in use. For members participating remotely, this will be visible in gallery view in its own thumbnail window on the platform, on the remote platform. Members are asked to wrap up promptly when their time has expired. And finally, while the recent guidance from the Office of the Attending Physician has made mask wearing optional at this time, please know that we have in our midst at both the member and staff levels, individuals who are immune compromised and or who may have immediate family members who are immune compromised. So as well as those who may not be vaccinated either due to medical reasons or because the vaccine is not yet available to children under the age of 5. Therefore, the committee strongly recommends that masks continue to be worn out of concern for the safety of unvaccinated and immune compromised committee members and staff and their families. So pursuant to committee rule 8C, opening statements are limited to the chair and the ranking member. This allows us to hear from our witnesses sooner, and it provides all members with adequate time to ask questions. I now recognize myself for the purpose of making an opening statement. Today, we're meeting to discuss the pervasive and serious consequences of wage theft and examine a legislative solution to protect workers' wages and hold unscrupulous employers accountable. Too often, dishonest employers cheat their employees out of wages that they are legally entitled to receive. This can take many forms, whether by paying workers less than the minimum wage, withholding overtime pay, or forcing them to work off the clock. Regardless of the form, it allows those employers who skirt the law to get richer and pushes the most vulnerable workers deeper into poverty. This is a multi-billion-dollar problem. Each year, dishonest employers steal at least $15 billion from workers' paychecks in minimum wage violations alone, with all forms of wage theft possibly exceeding $50 billion annually in stolen compensation. This has serious consequences for workers across the nation and disproportionately hurts women and people of color who are more likely to work low-wage jobs. According to a 2016 study conducted by the Economic Policy Institute, hourly workers cost 25% of their annual earnings. Now, that's more than $3,000 in stolen wages that could not be used for essential expenses like rent, groceries, or childcare. Ultimately, wage theft prevents workers from taking meaningful steps to enter the middle class. In fact, workers who suffer a minimum wage violation are more than 3 times as likely to be in poverty. Moreover, about 1 in 3 workers who are victims of a wage theft violation receive some form of public assistance. Although wage theft practices are already illegal under the Fair Labor Standards Act of 1938 or FLSA, the law's trivial penalties and damages provisions have not prevented wage theft. Furthermore, employers use a variety of legal loopholes to evade accountability. So today, FLSA civil monetary penalties are just $1,100 for wage and hour violations. And the Department of Labor's maximum penalty for repeated or willful violators is $2,203. So let me repeat that. An average hourly worker's lost more than $3,000 per year in stolen earnings. Therefore, it certainly looks like it is cheaper to willingly violate the FLSA than it is to pay employees what they are entitled to receive. And this is not only bad for workers, but it puts honest businesses that abide by the law at a competitive disadvantage. The FLSA also does not require detailed pay stubs or record keeping, which are critical for workers to confirm pay accuracy, and if necessary, establish a legal claim for stolen wages. So when workers do have the evidence to mount a case, their claims are often stymied by employer-imposed class action waivers and arbitration clauses. Simply put, current law favors dishonest employers over hardworking Americans. So if we want to raise people out of poverty, if we want to ensure Americans can enter the middle class, and if we believe that workers deserve a decent wage for an honest day's work, then we must enact a meaningful deterrent to wage theft and help workers seek justice. The Wage Theft Protection and Wage Recovery Act, which I'm proud to co-sponsor, is a responsible solution to deliver on that goal. The legislation increases civil monetary penalties and liquidated damages to meaningfully deter any business considering stealing their workers' wages. It also will help level the playing field for those businesses already playing by the rules. Further, the bill requires detailed pay stubs be delivered to employees regularly and adequate record keeping to provide employees information necessary to hold employers accountable in court for violating the law. And finally, it prevents employers from exploiting mandatory arbitration and collective action waivers, and it protects an employee's ability to pursue remedies for stolen wages under the law. I'm also pleased that President Biden's fiscal year 2023 budget proposes the necessary resources to help restore the Department of Labor's ability to enforce the FLSA after 4 years of staff cuts made under the Trump administration. However, more money cannot fix the deficiencies in the FLSA. If we as Congress know better, we should do better. Therefore, I'm committed to working with my colleagues to pass the Wage Theft Prevention and Wage Recovery Act of 2022 to ensure workers receive the wages that they earn. I now recognize the distinguished ranking member for the purpose of making an opening statement.
Thank you. All workers must be paid in full for their work. That is not in question or open for debate. Republicans fully support the enforcement of the Fair Labor Standards Act, FLSA. What we do not support is weaponizing this act or any federal legislation to be used against our country's job creators. Unfortunately, that is exactly what H.R. 7701, Congresswoman DeLauro's bill, is attempting to accomplish. First of all, Democrats' approach to employers is wrong. Referring to unintentional technical errors in payroll as wage theft demonstrates Democrats' hostility toward America's job creators. Employers want to do the right thing by their employees and pay them what is owed. People work hard and get the job done every day. I see that across central and northeastern Pennsylvania. Calling our country's job creators thieves is beyond outrageous and should have no place in our policymakers' discourse. It would be far more productive for the Department of Labor to provide compliance assistance to employers instead of assuming all employers are bad actors, which my Republican colleagues and I know is not the case. Both workers and job creators benefit from clear and concise compliance procedures, but Democrats' proposed changes to the FLSA would make employment and wage regulations even more convoluted. This legislation would then impose crushing penalties on employers for not being able to effectively navigate the maze of red tape it intends to create. This is nothing short of entrapment. We should be supporting easy-to-understand wage and hour rules, not impossible compliance burdens. The enforcement penalties are extremely punitive and could severely hinder employers, especially small businesses. This is not the way to treat those keeping our country's economy running. In fact, it is counterproductive. Further, the onerous mandates and disproportionate penalties in this bill will have a chilling effect on the ability of employers to offer additional benefits to workers, including greater compensation or flexibility. Employers want to do what is best for their employees, but the federal government is threatening to stand in their way. Democrats are completely ignoring the adverse consequences that will come from their meddling. In truth, this legislation is a massive power grab meant to substantially increase the federal government's control over the workforce. H.R. 7701 would fundamentally alter the FLSA by expanding its jurisdiction to all employer-employee contracts, including collective bargaining agreements. This legislation will harm America's job creators and workers. Whenever Democrats and Washington bureaucrats expand federal control over private businesses, it reduces innovation and the ability of businesses to respond to changing economic circumstances. This is not the way our country will recover from the pandemic, the worker shortage, or record high inflation. This legislation is short-sighted and destructive. In the case of bad actors, the FLSA already has strong remedies in place for employers who do not comply with the law. Instead of adding burdensome reporting requirements and increasing penalties, the Department of Labor should simply use existing law. Democrats continue to fail to recognize the importance of independent contractors in today's evolving economy, and this legislation would have a negative effect on their opportunities. If Democrats had their way, independent contracting would come to an end. Yet, independent contractors are serving a vital purpose in many industries, and workers seek out the benefits and flexibility these arrangements provide. If Democrats truly care about our people, they will start looking to bolster job creators instead of tearing them down. The truth is, we need more freedom in the marketplace, not less. Thank you, and I yield back.
Thank you very much. Without objection, all other members who wish to insert written statements into the record may do so by submitting them to the committee clerk electronically in Microsoft Word format by 5 p.m. on May 25th. I would now like to introduce our witnesses. Ms. Karen Case, is that Casey?
It's Case.
Case, excuse me. Okay, Ms. Case is the Labor Bureau Chief of the New York State Office of the Attorney General. As Labor Bureau Chief, Ms. Case has extensive knowledge of federal and New York wage and hour laws and the current realities of wage theft enforcement. Mr. Francesco Esparza is the representative for the United Brotherhood of Carpenters. Mr. Esparza has been a victim of wage theft himself, and he now draws on that experience to educate other workers about their workplace rights with the carpenters. Ms. Tammy McClutchin is the senior affiliate at Resolution Economics. Ms. McCutcheon provides expert services to employers on employment law, compliance issues, and previously served as Administrator of the Wage and Hour Division at the U.S. Department of Labor under President George W. Bush. I'd now like to turn to Representative Omar to introduce the final witnesses. Representative Omar will provide a brief introduction for Danielle Swanson-Clark. If Representative Omar is
Yes, thank you,
okay,
Chairwoman.
yeah, great, thank you.
Thank you, Chairwoman. I am honored to introduce Danielle Swanson-Clark, a small business owner from my district who has been advocating for workers' rights in our community and other communities across the country. Mr. Swanson-Clark is former middle school educator turned small business person and has owned and operated the Butter Bakery Cafe in Minneapolis since 2006. Danielle served as Minneapolis's Workforce Advisory Committee and helped launch its small business team, and currently serves as the representative of Kingfield neighborhood for local development projects. He's a board member of Main Street Alliance's Minnesota chapter and serves on the steering committee of RISE, a high road restaurant employer association. Danielle is currently assisting the Bloomington City Council to prepare and earn sick and safe time ordinance for their city. Danielle, thank you for making Minnesota proud through your leadership and tireless advocacy on behalf of working families. I yield back, Ms. Chairwoman.
Thank you, Representative Omar. These are the instructions for the witnesses. We do appreciate you for participating today. We look forward to your testimony. But let me remind the witnesses that we've read your written statements. They will appear in full in the hearing record. Pursuant to Committee Rule 8D and the committee practice, each of you is asked to limit your oral presentation to 5-minute summary of your written statement. So before you begin your testimony, please remember to unmute your microphone. During your testimony, staff will be keeping track of time, and the timer is visible to you at the witness table. Please be attentive to the time, wrap up when your time is over, and remute your microphone. We'll let all of the witnesses make their presentations before we move to member questions. When answering a question, please remember to unmute your microphone. The witnesses are aware of their responsibility to provide accurate information to the subcommittee, and therefore we will proceed with their testimony. I'd like to first recognize Karen Cacase. And Ms. Cacase, you are now ready to give your testimony.
Good morning, Chair Adams, Ranking Member Keller, and distinguished members of the subcommittee. My name is Karen Cacase, and I'm the Bureau Chief of the Labor Bureau at the Office of the New York State Attorney General. Prior to joining the Office of the Attorney General, I was the Director of the Employment Law Unit at the Legal Aid Society in New York City. I want to thank you for convening this important hearing at such a vital time for workers and for giving our office an opportunity to share our experiences and insight. The Labor Bureau of the Office of the New York State Office of the Attorney General enforces federal, state, and local laws affecting workers in New York State. Our office prioritizes enforcement of wage theft against low-wage workers. Our office recently resolved several wage theft investigations, including investigations involving home health aides, restaurant workers, and residential building staff. While I was at the Legal Aid Society, the Employment Law Unit litigated many cases of wage theft in different industries, including for restaurant workers, domestic workers, and residential building services employees. Wage theft continues to be a devastating issue for low-wage workers across industries. It is an area that requires legislation to increase protections, deter violations, and encourage greater enforcement. There are several potential amendments to the Fair Labor Standards Act that would significantly improve the law. The Fair Labor Standards Act has not increased the minimum wage since 2009, and it provides that workers who are required to be paid the minimum wage be paid only $7.25 an hour. In contrast, the New York labor law provides that within New York City, Long Island, and Westchester, the minimum wage is $15 per hour, and throughout the rest of the New York State, the minimum wage is $13.20 per hour. In addition to minimum wage increases, there are other important protections that can be added to the Fair Labor Standards Act. For instance, as part of the New York's Wage Theft Prevention Act, which went into effect in 2011, New York requires that employers provide employees a hiring notice that explains whether they are covered by the minimum wage laws, and if they are, what their hourly wage and overtime rate will be. This notice must be provided in English and the employee's primary language. Without this protection, workers may not know that there are any wage laws that apply to them or that they are entitled to a specific hourly rate. Another important provision of New York's Wage Theft Prevention Act is that employers are required to provide employees with pay stubs, which detail how many hours they worked each week and the amount that they are being paid per hour. This allows workers to review the number of hours they are being paid and to address any issues immediately and seek legal assistance. If hiring notice and pay stub requirements are enacted, it will be easier for workers to prove wage theft claims. Sometimes employers report on pay stubs that they are paying workers less than the minimum wage and thereby hand the workers strong evidence of the violation. If employers fail to provide the pay stubs, employees may prove their claims through their own credible testimony. Penalties for failing to comply with hiring notice and pay stub requirements are also important. In addition, the New York labor law provides that workers must be paid their promised wage. And if an employer promises to pay an employee a rate above the minimum wage, it's a violation of the New York labor law. This is important because the New York labor law violation allows attorney's fees and it allows liquidated damages, something that a regular breach of contract claim does not allow. Another issue that is prevalent is for employers to fail to pay employees their last paycheck. And so additional penalties for that violation are significant because they will encourage lawyers to take on those cases, which can be for a small amount of wages, but are still significant to the workers. Increasing penalties overall may be the most effective method of deterring employers from violating the substantive provisions of the Fair Labor Standards Act. For many employers, the cost of having to pay their employees once a wage theft claim is filed is not significant enough to deter them from violating the law. It is also essential that workers be allowed to pursue wage theft claims jointly or in groups by bringing a class or collective action. The time and cost of a wage theft litigation is difficult for an individual worker to bear alone. Finally, lengthening the statute of limitations is also important. Low-wage workers are often unaware of their rights, and it may take them time to recognize that there have been violations and to find legal representation.
We also want to let you know that
In New York, the statute of limitations is 6 years.
Yeah.
We very much appreciate the opportunity to share our input with you here today and welcome the chance to continue this conversation. Thank you.
And thank you very much. We'll now hear from Francisco Esparza. You are recognized for your testimony.
Good morning, Chair Scott, Ranking Member Fox, and members of the Education and Labor Committee. I appreciate the opportunity to testify today on my experience and expertise on the issues of workers' rights, wage theft, and the uneven process of wage recovery for victims of wage theft. I am Francisco Esparza, and I am a council representative for the Eastern Atlantic States Regional Council of Carpenters, a union carpenter and a former victim of wage theft in the construction industry's underground economy. I came to the United States 18 years ago when I was 11 years old. I am a dreamer. As a DACA recipient, I understand that I am fortunate to be able to have a career in this country and the ability to work for all that I earn. To be honest, that realization is not one that comes easily to many people like me. Countless construction workers, especially in the District of Columbia, see themselves as voiceless and invisible. In the underground economy of the construction industry, you are told you are lucky to have a job in general and will be compensated by the means dictated by your employer or your labor broker. This is not how things should work in this country, but all too often they do. It takes education, some courage, and self-respect for many to decide that they have been cheated and deserve fair compensation. In 2019, myself and 222 others started to speak up and take action to receive the $618,000 in stolen wages we earned. Our class action lawsuit against Contractor and Johnson was for unpaid wages, unpaid overtime, and workplace fraud under federal and District of Columbia law. This was a major victory for workers who do not think they have a voice. It was historic because it is so rare. Without the laws put into place in the District of Columbia, we would have not had the ability to take this step. The District of Columbia has stronger than average laws in place to help workers fight back against wage theft. The district's Minimum Wage Act, Wage Payment and Collection Law, and Workplace Fraud Act provide more opportunity for workers.
Excuse me, Mr. Esparza, can you turn your volume up, please, sir? We're having difficulty, some of the members hearing you. Turn your volume up just a little bit more.
How do I do that?
Let's see, should be at the bottom of your computer. If you move can someone give him some instructions about?
Thank you.
If you'll speak up a little bit, maybe that'll help.
Mr. Esparza, if you could, sir, in the bottom left-hand corner of your screen should be your microphone mute button. In the corner of that microphone button is a little arrow. If you can click on that little arrow and go to audio settings, sir, you should see a separation for mic and speakers, and you should see test microphone with a little bar that you can drag to the right. If you can please drag the bar to the right to increase your microphone pickup, sir. Thank you.
Better?
Yes, that is. Thank you, sir.
I apologize.
We stopped the clock, so you're not gonna lose any time. Okay, go proceed.
Okay, the actions workers have taken have not deterred unscrupulous contractors and labor brokers from stealing wages on the most vulnerable workers so that they can profit more. These profits are not only on the backs of workers they victimize, but the honest US taxpayers like me. Workers' compensation, funding for American infrastructure, our schools, veterans programs, and more are not paid into because of these actions. Recent studies and research show the issues are still prevalent and more enforcement and changes to our laws are necessary. In a national study by researchers and economists from Harvard University, Michigan State University, and Allegheny College, it was estimated that we have lost on $8.4 billion in state and federal tax revenue. Additionally, the study found that possibly 2.16 million construction workers are misclassified or off the books. There's a $1.7 billion shortfall on workers' compensation, $725.1 million in unemployment insurance, and $811.1 million in overtime not paid. The District of Columbia has taken steps to improve our workers' ability to fight back against these crimes, but studies have found that workers are still victimized in DC all the time. A 2021 survey of workers found that nearly 50% of those surveyed are part of the underground economy. These workers reported that instead of receiving a paycheck with a pay stub and with taxes deducted, they were being paid with a personal or business check without any payroll deductions, or they simply being paid in cash. After I was educated by the Carpenters Union on my rights, I joined the class action lawsuit against N. Johnson. I became a union carpenter. I did this to protect myself and earn the fair wages I deserve with the backing of a union that will fight for me. I later was fortunate to become a council representative. I take this responsibility very seriously. I was once a voiceless worker. Now I am the voice for not only the union carpenters I represent in the District of Columbia, but also the non-union workers looking for help. I hope my testimony and experience was helpful to you. Congress must act so that the Wage Theft Prevention and Wage Recovery Act is made law. Your actions to strengthening penalties on violators, improving workers' ability to pursue wage theft claims, expand outreach to workers and businesses on the issues, and facilitate the collection of evidence to assist in enforcement can help a worker gain the wage they deserve and hopefully help deter these crimes in the future. Workers deserve better in this country, and with your help, we will see less victims in the underground economy. Thank you again for your time.
And thank you very much. Thank you for your testimony. We'll now hear from, I want to recognize Tammy McClutchin. McClutchin, we're ready for your testimony. You have 5 minutes.
Thank you. Chairwoman Adams, Ranking Member Keller, and members of the subcommittee, thank you for the opportunity to speak with you today. Protecting vulnerable low-wage workers has been the focus of my entire wage and hour career, first by expanding strategic enforcement in low-wage industries while serving as wage and hour administrator, and then by conducting audits of employer pay practices to find and correct FLSA violations. I believe we all have a common goal: do what we can to ensure that workers are paid in compliance with the FLSA and receive that pay when they perform the work, not months or years later. Justice delayed is justice denied. There is nowhere truer than when low-wage workers must wait months or years to be paid. This workforce is often transient, and the longer it takes to recover wages, the harder it is to find the workers to give them their hard-earned money. The debate is how best to accomplish our common goal. I bring a unique perspective to the problem. During my career, I have seen the worst of employers and the best of employers. I have seen horrible practices. I have seen fabulous practices. I have seen bad people do bad things. I have seen amazing people do fabulous things, but still miss the compliance mark. I have thought about this problem for 20 years, and these are the conclusions I have reached. We need clear and simple rules. We need swift and certain enforcement. We need to punish the bad while rewarding the good. Achievement of these goals will require meaningful reform, but I'm afraid that the current bill will not improve protections for low-wage workers. Let me tell you why. The provisions on disclosures, pay stubs, final pay, and the right to full compensation are covered under state law. Adding federal requirements would add complexity and confusion without actually improving the worker protections. We need to simplify the FLSA, not make it more complex. Making compliance more difficult will decrease compliance and thus harm workers. State contract laws, union CBAs, and arbitration procedures already ensure workers receive their full compensation. Also, wage and hour investigators have no training or experience in enforcing private contracts or CBAs. The heart of the bill focuses on enforcement: new and increased back wages, liquidated damages, civil and criminal penalties. These increases proposed are extreme, and I fear will be counterproductive of the goals of this bill. Increasing the financial consequences for violations makes a great headline, but I urge you to think about the actual impact on low-wage workers. Employers faced with such massive damages and penalties will have only one way to react to violation allegations: litigate, litigate, and litigate some more. Payment of back wages would be delayed by years. The plaintiff's bar will collect more fees, but low-wage workers, I am afraid, will see nothing at all. The proposed increases also are inflexible, with no room for discretion based on the size of business or the type of violation. Any increases should be lower for small businesses, which have fewer resources to ensure compliance, and should be limited to repeat, willful, and retaliation violations. I don't understand at all why a bill focused on protecting low-wage workers would include provisions on litigation. There are no limits to the ability of employees to unite and pursue lawsuits against employers. The Department of Labor litigates on behalf of all employees. Plaintiffs' attorneys file thousands of wage and hour class actions and collective actions every year. Removing the FLSA opt-in litigation procedures, especially without any replacement, will generate confusion and more litigation, which benefits only lawyers. Arbitration is cost-effective. It's quicker, with significant protections for workers. Swift resolution of wage claims is essential to protecting low-wage workers, and arbitration can do that. Litigation cannot. Tolling the statute of limitations during agency investigations also would delay payment of back wages. DOL does take too long to resolve complaints. Tolling would remove any incentives of the Wage and Hour Division to move more quickly. A better approach is to set metrics and create incentives in the agency for a quick resolution and reduce time for investigations. I have only time to discuss one of my concerns with the grant program. Deputizing advocates to help conduct investigations would eradicate the long tradition of employers voluntarily cooperating with agency investigations, producing documents, welcoming investigators into their work sites. But if DOL brings along unions and advocates, employers will stop cooperating and insist on search warrants and document subpoenas. After all, the Fourth Amendment does apply. More complexity, longer investigations, more litigation will harm low-wage workers by delaying payment of wages. We need to find a better path. Thank you.
Thank you very much. We'll now hear from Danielle Swanson-Clark. You are recognized for 5 minutes.
Thank you, Representative Omar, for your kind introduction and your strong support of small businesses like mine in Minnesota's 5th Congressional District. We certainly appreciate you taking the time to meet with small business owners from Main Street Alliance last week during our May Small Business Month of Action. Chairwoman Adams, Ranking Member Keller, and members of the subcommittee, thank you for the opportunity to address you today. My name is Danielle Swanson-Clark. I've owned and operated Butter Bakery Cafe for the past 16 years in Minneapolis, Minnesota. I'm also here on behalf of Main Street Alliance, a national network of small businesses working to build people-centered, community-focused local economies. In my ideal world, fair wage laws wouldn't be necessary. What if instead we valued everyone fairly for their labor, providing each person with what they need in order to help them thrive? Sadly, that is not the history of our country, and those unfair labor practices don't actually ring true to the ideals of our country. As a result, there's been a long and continual process of undoing those harms and righting the wrongs. The fair labor laws developed over many years are one way of moving closer to those goals. This philosophy has been at the core of my business. I learned about fair wage laws by doing. My first job out of college was as the sole employee of a small nonprofit community center in Baltimore. And while I had held jobs before as an employee, I quickly needed to understand what it meant to also be an employer. I learned about payroll reporting and taxes and how to decipher IRS letters through a great mentor who walked me through it and taught me the basics of accounting. Those lessons stayed with me over the years as I worked in public and charter schools, in nonprofits, in self-employment, and finally now as a for-profit business owner. Technology available to me now that didn't exist in the mid-'80s makes preparing payroll on your own accessible, even if you don't use a payroll service. I recognize that the complexity of payroll can at times be baffling and frustrating. I still make mistakes. I am still learning. But the process of hiring staff, setting up payroll, and retaining staff through fair labor practice is fundamental for business owners. The benefits of providing clear rules and policies far outweigh the effort to create them. The technical assistance available in many forms and with willing mentors it's a business owner's choice to not play fair. As someone who chooses to play by the rules, I lose out to business owners who bend those rules and use their power and privilege to avoid paying a fair wage. When I price my products fairly to represent a true cost of labor, I get questioned by lower prices elsewhere. Because I had worked in the restaurant industry and knew its issues with wage theft, I was willing to work with my staff to deal with systemic inequities, create a fair wage model, treats all my staff as professionals. My staff appreciate the ability to know what they'll make when they come to work. When our city added an earned sick and safe time ordinance for staff in 2016, we were at the lead teaching other businesses how to adopt it and build it into their payroll reporting. During 2018 and 19, I had the opportunity of serving on Minneapolis's Workforce Advisory Committee, which worked to craft a wage theft ordinance. A key component was an employee notice, which would spell out the terms and conditions of employment for every staff member. We modified a state template for our city, and it's an easy form. I complete it each time I go through the hiring process. During our research on wage theft, one of the stories that bothered me the most was the large national chains that were willing to encourage wage theft practices, knowing that in nearly all states, restitution was limited to federal minimum wage. And that wage was lower in many states, and so they would come out ahead, even if they were caught and lost. My staff gain a sense of agency in their role as an employee with a clear employee notice. My workers appreciate the openness and transparency. They appreciate a clearly spelled out policy for wages and payroll reporting. The tasks of hiring and setting up payroll should include this information. Your efforts to define what that notice include are helpful, not harmful. I can meet those compliance requirements. Thank you for continuing the effort to undo fair labor practices of the past and work with small businesses to build a sustainable economy. vibrant neighborhoods, and strong communities across this country. I am happy to answer any questions you may have.
Thank you very much. Under Committee Rule 9A, we'll now question witnesses under the 5-minute rule. I'll be recognizing subcommittee members in seniority order. Again, to ensure that members' 5-minute rule is adhered to, staff will be keeping track of time. Please be attentive to the time, wrap up when your time is over, and remute your microphone. As chair, I'll now recognize myself for 5 minutes. Ms. Cacase, under current law, the FLSA provides that workers who are victims of wage theft can only be compensated for unpaid hours of work at the federal minimum wage rate of $7.25 an hour. And that would mean that a worker earning $10 per hour who was a victim of wage theft would only receive back wages at the rate of $7.25 per hour. So how does this current limitation on damages under the FLSA harm low-wage workers?
Thank you, Chair Adams. Your question points out a significant problem. If you have an agreement with your employer to get paid above the federal minimum wage, which is only $7.25 an hour, even if they don't pay you the $10 an hour they said they would, if you are suing under the Fair Labor Standards Act, you cannot currently sue for that $10 an hour. You are only able to sue for the $7.25 an hour. So workers are not able, there's no way for them under the Fair Labor Standards Act to obtain the money that your employer agreed to pay them and that they earned. And this significantly diminishes their damages. If you work at $7.25 an hour for 40 hours a week for 50 hours a year, it comes out to only $14,500 per year. So you have somebody who's full-time working, making just $14,500 and only able to collect that much money, even if they were promised a wage of $10 an hour.
Okay, thank you for that. Raising the federal minimum wage is an issue of great importance to me and many of the members of this subcommittee. I appreciate your testifying and speaking to the importance of the issue. But Ms. Cacase, as you know, wage theft disproportionately impacts workers of color, including Black women. In your experience as a Labor Bureau chief and as legal aid attorney, can you share some of the ways in which wage theft impacts our most vulnerable communities?
Yes, of course. The low-wage workers work paycheck to paycheck, so they do not have savings in the bank if their employer does not pay them the wages they're owed for the last week. So what happens is, as you mentioned in your opening statement, they're unable to pay their rent. They're unable to buy groceries, to pay their utility bills. And when I was at legal aid, we would screen every worker that came in for an employment law issue for any other issues, and often they would already be in eviction proceedings. There would already be, a scarcity of food in the house. And so there are so many fundamental issues that develop from not getting paid your minimum wages every single week, and the stress that puts on a person is enormous, and people are really suffering. And so any amendments to the Fair Labor Standards Act that will increase the ability to enforce the law will be an enormous benefit to these workers.
Thank you very much. I've got a few minutes left. Mr. Swinson-Clark, as a small business owner, what would you say in response to the argument that providing pay stubs and pay records to employees is too burdensome?
I am currently providing pay stubs and all of the information required. I don't feel like it's a burden at all to me. It's a one-step click of a box, and in this case, I'm not afraid of it.
Okay, so it doesn't appear to be a burden to you.
Not at all.
You've been doing it for how long?
For 16 years.
Okay, all right. Well, it sounds like you have the model. But thank you very much. I have a little time left. I'm gonna yield my time back, but I also want to now recognize the ranking member for the purposes of questioning the witnesses. Ranking member Keller, you're recognized, sir.
Thank you. Ms. McClutchin, thank you for being here today. Democrats have long been hostile to the independent contractor model, which has offered flexibility and well-paying opportunities to millions of Americans. Are you concerned that the burdensome requirements and excessive penalties in Congresswoman DeLauro's bill would have a chilling effect on the ability of independent contractors to find work?
Oh, absolutely, Representative Keller. And thank you for asking. Now, you know that there are over 10 million open jobs right now in this country. And at the same time, in 2021, over 12 million workers joined the independent workforce. That's according to a study by MBO Partners. By the way, 55% of those are women, and 68% are Gen Z and millennials. The vast majority are choosing to do that voluntarily and are happier and healthier, according to this report. Now, employers need to tap into this workforce. 12 million versus 10 million open jobs, but uncertainty caused by, for DOL's illegal withdrawal of the Trump administration's IC regulations, and then coupled with this massive increase in penalties, means that no rational employer would actually want to engage the independent workforce, which they really need to be able to do.
Thank you. Also, Ms. McClutchin, the Fair Labor Standards Act covers roughly 143 million workers and the diverse businesses of all sizes that employ them. Are you concerned that the burdensome requirements contained in Congresswoman DeLauro's bill would unduly impact small businesses?
Yes, you might as well call this bill the Bankrupt Small Business Act. Small businesses do not have in-house attorneys. They can't afford outside employment law specialists. They don't have professional HR. They primarily rely on the advice of their accountants, who, I'm sorry to say, just do not know the FLSA sufficiently. Guidance for the small businesses is really hard to find on the Wage and Hour Division website. Sometimes I can't find it. So many small businesses, even when under current law, need a payment plan to repay the back wages they owe, and let alone the excessive penalties proposed here. I have seen small businesses bankrupted, but perhaps, I don't know, perhaps that's the goal. The current leadership at DOL targeting ICs, franchisees, guess what? Bankrupt small businesses can't employ any workers at all.
And this might be for, as you mentioned, the regulations are not clear and their guidance isn't always there. So a small business, if they would make a mistake or something, it would be detrimental to them. Because is that a lot of what we find, that businesses might have made a mistake, an error in trying to sift through the regulation?
Yes, and that's the problem with the word wage theft and talking about this as if they're criminal activities. Good employers make mistakes because compliance is hard, and this bill does not distinguish between the good faith employer who makes an error versus the really bad actors that are out there.
Yeah, and we all want to hold people that are intentionally doing things wrong accountable. I think that's the minority of people. I mean, I noticed in Mr. Swinson-Clark's testimony, he recognized that the complexity of payroll at times and can be baffling and frustrating, and he still makes mistakes according to his own testimony. And I don't think they're going after the right thing. Mr. Platt, I don't think you're doing those things on purpose, are you?
Indeed not. And
Okay,
it has been my experience.
That just proves the point that this legislation is going to be detrimental to people, and the vast majority of the employers in the United States want to do the right thing for their employees because they're employees. I mentioned in my opening statement how I recognized that going across central and northeastern Pennsylvania. But when I was in high school, I worked in a restaurant, I worked in a nursing home washing pots and pans, and I worked in a factory right out of high school. And I tell you what, the people that owned those businesses back in the early and mid-'80s, guess what? They cared about the people that came to work every day. They wanted to do the right thing. So I just think that we as policymakers need to quit demonizing the people we represent that create jobs every day. Thank you, and I yield back.
Thank you very much, Ranking Member. I'll now recognize Mr. Takano. You're recognized for 5 minutes. Go ahead.
Thank you kindly, Madam Chair. Ms. Kakich, what do you have to say about the allegation that this law, this proposed bill, doesn't make a distinction between mistakes and willful stuff?
Well, the liquidated damages they are more significant if it is somebody who has engaged in willful behavior. So it definitely does make a mistake. But I think that the important thing to recognize is that this bill, the only additional substance that it's requiring of employers is to give a pay stub. A pay stub is the most basic thing that an employee should receive from their employer. They should know exactly how much they are getting paid. They should know for exactly how many hours their employee is paying them. That is not too much of a burden. It is not too complicated. And under the Fair Labor Standards Act, it's necessary because many states do not have that requirement. So this is an essential protection that is not going to burden anyone. And any small business that complies with that will have there's no penalties. There's, pay your workers the right amount, and nobody is bankrupting your business.
Thank you. Ms. McCutcheon indicates that both federal and state laws on the pay stub disclosure requirements would, in her words, quote, lead only to more complexity and confusion when employers try to figure out which law is more protective, end quote. But this doesn't make any sense to me. I think employers like Mr. Platt are smart enough to figure it out. Do you agree with Ms. McCutcheon that a federal pay stub requirement such as the one that you described would lead to more complexity and confusion?
No, as I said, I think the pay stub requirement is a very basic requirement. It is absolutely the bare minimum that you should give your employees. I do not think it will be more complicated for businesses, and they should be able to figure it out.
I'm astounded, quite frankly, in this case, that that there isn't a national requirement for pay stub. I receive a pay stub. I know the ranking member and every member of this committee, Republican or Democrat, receives a pay stub. Every one of my employees receives a pay stub. It's common sense that we need a pay stub to figure out whether or not we're receiving the full amount that's due. We can actually go back and look at whether or not we're being paid the minimum wage or whether we are paid overtime that we are deserve, and we can dispute with our supervisor. I think if all this bill is doing is saying every American worker should get a pay stub detailing their deductions, I think most Americans would say that this is common sense. Mr. Swanson-Clark, Ms. McCutcheon says that the Wage Step Act's proposed increases to the penalties for violating the Fair Labor Standards Act are, quote, very significant and even ridiculous, end quote. I don't believe it's ridiculous to hold businesses accountable for stealing workers' wages. What do you think?
I would find it a little more ridiculous to not charge someone for stealing. If I were to take my employees' wages after they took them out of the bank, I'm sure I would be in trouble. But if I do it before they get to put it in the bank, I should also be in trouble. So I don't think it's ridiculous at all to take on the bad actors, to let them know that this is not the way to play business.
Mr. Swinson, you kind of alluded to the big national chains and some of their practices, how you have to compete against some of their bad acting. Can you tell us a little bit more about what you've experienced and what you've seen?
Within our own city, it's pretty clear that the wage levels here are much higher than across the country. And so when a company can use that difference to get the federal minimum wage as the base, they're cutting wages for those staff who work in our city. I have to pay my staff in this city the full wage. And that's a pretty big discrepancy. They can certainly outcompete me in a lot of ways by not having to do that.
Madam Chair, I yield back, but I'm astounded that that workers cannot recover the minimum wage that is set in Minneapolis, that's higher than the federal government. They can only recover what the federal government has set at $7 and change. I find that astounding. I yield back.
Thank you, sir. Thank you very much. I want to now yield to the gentle lady from North Carolina, the ranking member of the Ed and Labor Committee, Representative Fox, you're recognized.
Thank you, Madam Chairman. Ms. McCutcheon, thank you very much for being here and for your very positive opening statement. The DeLora bill creates a new requirement for DOL's wage and hour division to enforce all employment contracts and collective bargaining agreements. Ms. McCutcheon, based on your time leading the division, are you concerned about the division's ability to enforce this mandate, and what implementation issues would the division face?
Yes, I'm very concerned. That type of contract claim is totally outside of the wage and hours experience, and indeed the attorneys in the solicitor's office too. They do not know contract law, and certainly I would suggest that unions are the experts at enforcing collective bargaining agreements. So you would have to develop, the agency would, new training and train every investigator, and it's not an easy new type of law. And all that time, training new investigators, developing the training, every minute of that would be spent away from helping low-wage workers. And I'd also like to suggest employees who have contracts and union members under collective bargaining agreements are not the low-wage workers that we should be focusing on here. So it's just a bad idea all around. And believe me, they have remedies. It's called state contract laws and enforcing collective bargaining agreements.
Thank you. Ms. McCutcheon, the legislation we're discussing today would force a business to comply with stringent disclosure requirements that would include unnecessary paperwork and costly analysis. How would these costly requirements subvert the legislation's stated goal of benefiting workers?
Well, first of all, let me correct the record. Every employee gets a pay stub because every state does have a pay stub requirement. Some of them require more and some less, but pay stubs do exist. Everybody gets them. But adding additional disclosures would mean additional time. It means working with your payroll provider to make sure that your pay stubs actually comply with the law that's more prospective, California versus federal, for example. Under California law, you have to list total wages, not just total hours, not just regular and overtime. This law would just do regular and overtime. So it is confusing because there's this would add 51 laws that you have to comply with rather than just your local state or numerous of states. So I would rather employers spend the time instead of trying to comply with unnecessary paperwork, which we frankly don't know whether it helps low-wage workers, whether they even would read this additional paperwork. I'd rather spend the time and money and resources on enforcement of the bad actors and for low-wage workers.
Thank you again. Ms. McCutcheon, 5 years ago, a witness testifying before the committee representing the Society of Human Resource Management discussed the challenges of complying with FLSA requirements in the modern workplace and how the FLSA has not kept pace with the 21st century economy. Do you agree that employer compliance with the FLSA's wage and hour requirement has become more complicated in light of technological developments? How has the COVID-19 pandemic accelerated this trend?
Yes, absolutely, I agree. The core requirements of the FLSA, you recall, were enacted in 1938, and the workplace today is nothing like the workplace 80 years ago. Then we were primarily a blue-collar manufacturing economy, and now, today, we are a service economy with more independent workers. And COVID just accelerated all the changes, where we work, how we work, the types of jobs, the types of pay. It's more complicated to track hours. It's more complicated to calculate overtime. It's more complicated to figure out who is exempt from overtime and who is not. And yes, we need to help low-wage workers, but we need to focus on reforms that will do that. Simple, clear rules and quick enforcement is what we need.
Thank you, Madam Chair. I yield back.
And thank you to the ranking member. So I want to recognize Mr. Stefanik now. No, let's see. Mr. John Paul, excuse me. Representative John Paul, you are recognized.
Thank you so much, Madam Chair. Wage theft is indefensible, especially as corporations rake in record profits. Funding for the Wage and Hour Division to combat wage theft has essentially remained flat for the past decades thanks to corporate lobbying. In addition to beefing up federal enforcement, we have to take an all-of-the-above approach to protect workers' paychecks. One of the most effective recourses for workers is litigation. Between 2017 and 2020, class action lawsuits recovered more lost wages than Labor Department action, and yet many employment contracts contain provisions that waive a worker's right to a day in court by subjecting them to mandatory arbitration and preventing them from bringing class action lawsuits. That's why I'm a proud co-sponsor of the Wage Theft Prevention and Wage Recovery Act, which bans these coercive practices against workers fighting to win their hard-earned wages. Mr. Esparza, thank you for sharing your story. I think it's too often that immigrant workers get overlooked and erased, even as they face very unique challenges. If you had been required to sign an employment agreement that mandated you to bring your wage claim in arbitration as an individual and pay out-of-pocket arbitration costs, do you believe that your wage claim would have been successful?
It would not be successful at all because, I mean, I don't have the resources to do it by myself. That's why the union supported me, and thanks to them, I was able to do these class action lawsuits. Without them, I wouldn't be able to.
You wouldn't have been able to do it. It's just too expensive and you wouldn't have had the resources. On average, a worker experiencing minimum wage violations lose about $3,300 in 1 year, more than a month of rent in a city like Seattle, but a small sum compared to the cost of litigation. Ms. Kakas, would an individual low-wage worker be able to easily find legal representation for such a claim?
No, definitely not. I mean, I before even being at Legal Aid, I was in private practice, and it was very difficult for us to take claims of low-wage workers because the recovery, even though significant to the workers, was not small enough to, it was not great enough to warrant the resources put into the litigation. And so the ability to bring collective and class actions is really essential, so workers can have their rights vindicated and can receive the money that they owe. And going to arbitration is not the answer. Arbitration is not as efficient as it is claimed to be. We had a recent case here in New York where the arbitration took over 3 years for a group of home health aides. So it really it's important that workers have the right to litigate in court.
Well, let me follow up on that because you were just starting to get at my next question, which is why do employers prefer settling wage theft disputes in arbitration rather than in the courts? Because if you look at the data, more than half of private sector non-union employees are subjected to this forced arbitration. So what's in it for the employers?
So many arbitration agreements say that a worker has to arbitrate individually. So for instance, there's currently a collective and class action against Uber and Lyft in New York State brought by the Taxi Workers Alliance. And that claims for thousands of workers. The companies have claimed that all of those workers are subject to individual arbitration. So thousands of individual arbitrations. It would be impossible to find representation to do that, and it would take decades to individually arbitrate each one of those claims. So it's more efficient to have class and group actions that can go into court.
So in a way, it's really it's an effective way to quash many of these complaints from workers to be able to get what's fairly owed to them. Let me stick with you and say that the Wage Theft Prevention and Wage Recovery Act includes a provision that would automatically include qualifying workers in a class action lawsuit instead of requiring them to opt in. How will that impact the strength of class action cases and Fair Labor Standards Act enforcement?
I think that makes sense because when workers often receive an opt-in notice, they're afraid that, you know, they would be making themselves known. They could be currently still working for this employer, and it's a difficult decision whether to opt in because of the fear of retaliation. So if they don't have to take that affirmative step until after the case is over and there's going to be recovery, I think a lot more workers will get the compensation that they earned.
Thank you so much. And Madam Chair, I'm proud that the House has passed the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act, my bill with Sherry Bustos, and that the Senate passed it and got signed into law. I hope we can eliminate forced arbitration and provide limitations on class action and eliminate the limitations on class action with this bill. Thank you very much. I yield back.
And thank you. I want to recognize now Mrs. Miller Meeks of Iowa. You have 5 minutes, ma'am.
Thank you, Madam Chair and Ranking Member Keller. And thank you to all of our witnesses for their important testimony. Ms. McCutcheon, you had done an excellent job, and thank you for appearing here in person, of describing the onerous implementation regulations around the FLSA and how difficult it is for a business that wants to comply and is paying a fair wage to comply with those regulations. The FSLA does not define the term joint employer. Congressional Democrats and the Biden administration support creating the broadest definition possible of joint employment and do have concerns about how broad joint employment definition would work with the DeLauro bill, and would it significantly increase liability for employers and threaten the franchise business model?
I think it would kill the franchise business model and also ruin many small businesses. Because they cannot afford the tripling and quadrupling of penalties that this bill would propose, especially in the franchisee business. What company would have franchisees when they're going to be held responsible with these extreme penalties for every minor violation by every single franchisee who is a small business? Better to just have company stores where you can control the pay and the pay practices of the employees in the storefronts with your brand on it. So the broader the anti-joint employment is anti-franchise and anti-small business.
And I know that our small businesses in Iowa are extremely concerned about this, and they're paying, in many cases, well over $15 an hour. Your testimony discusses the complexity of the Fair Labor Standards Act and the value of streamlining requirements. During the Trump administration, DOL issued a final rule on workers' classification as employees and independent contractors under FLSA. This rule emphasized the degree of workers' control over their work and their great entrepreneurial opportunity for profit or loss. Does this rule provide greater certainty for workers and businesses?
Absolutely. Before that, there were no regulations. There was no clear standards at all. It was only informal guidance, which you had to be an expert to find on the Wage and Hour Division website. So these were regulations. They were focusing on who controlled the work, which is the commonality in all, sorry to say this, 100 different federal and state regulations and statutes on independent work. Now, of course, the Biden administration withdrew that rule. A Texas court said that was illegal, and it is back in force. But here's more confusion. It's not on the Wage and Hour Division's website. They're the Trump regulations that are in force today. What we see on the website is a notice about the law, but not a link to the actual regulations, and they have instead their fact sheet 13, which is a 7-factor test that was in place before the regulations. So to help small businesses and franchisees, they need to put the Trump regulations back on their website and take off fact sheet 13.
So it sounds like that clarifying language needs to be present, and we need to stop practices where we know it's illegal, but we're going to continue to do it. In March of this year, a federal court held that efforts by the Biden Labor Department to withdraw the Trump administration's final rule on independent contractors were invalid, to your point, and that the Trump rule, which became effective in March 2021, remains in effect today. And I think you alluded to this, do you know whether the department is following the Trump administration work classification rule, and will they put it back on their website? Or is that an indication they're not following it?
I don't know. I don't think anybody knows whether they're actually following the law as they're required to do under the Texas District Court. I also don't know whether they're going to appeal that case. So we're in total disarray right now. My advice to employers is the rule is the Trump rule, and that's the rule that you should insist DOL and in litigation be applied.
Thank you so much for your testimony. Ms. Chair, I yield back my time.
Thank you very much. Representative Omar, you are now recognized for about 5 minutes, ma'am.
Thank you, Madam Chairwoman. Thank you, Mr. Swanson-Clark, for joining us today. Can you please detail how illegal payroll practices from certain companies end up hurting businesses like yours and your employees?
Thank you. You know, it's been my experience that when I've made a mistake with any of my payroll issues, I get opportunity to learn. I've had great experience with the IRS in working through any issues. I haven't had any fines that I've needed to be afraid of. And when I hear about businesses that break rules willingly, make efforts to skirt the law in order to gain some competitive advantage, I feel like all the work I'm doing is kind of at a loss. It also just makes me feel like my consumers, my workers, my community feels devalued for their labor when they know that businesses on a large scale can avoid paying a fair wage.
Thank you. Democratic AG offices across the nation have been working hard to protect workers' labor rights and make sure the economy is safe and sustainable for historically disenfranchised communities. And so I first want to thank Ms. Kakesi for fighting for working families in New York. You mentioned in your testimony that your office and state legislature enacted vital reforms to require universal payroll transparency and enforce tougher legal and monetary repercussions for wage violations. In 2019, the Minnesota legislature passed similar worker protection, which also authorized criminal penalties and increased civil fines for wage theft. That same year, my good friend and predecessor, Attorney General Keith Ellison, established Wage Theft Unit that is dedicated to advancing and protecting the rights of exploited workers. Over the past couple of years, our AG's office has won hundreds of thousands of dollars in payback, unpaid overtime, and other damages for workers in my district and across the state. Unfortunately, some of the most pervasive cases of wage theft in my state still occur in construction industry, where almost 1 in 5 construction workers suffer some type of payroll fraud and misclassification. A very recent example of this happened last week, where workers claimed wage theft for more than $100,000 by subcontractors at the Viking Lakes development in Eagan, Minnesota. It is clear that more DOL funding and additional federal reforms are needed to assist our localities in protecting the most vulnerable workers. How do you think the Wage Theft Act aids in your legal work?
Thank you for your questions. So as we're talking about the pay stub requirements, I think that it's important not only so workers know each and every week what they are getting paid for, and so they can address any discrepancy immediately. But if they need to litigate, those records are really invaluable. So we have seen cases in our office where even though the minimum wage is $15 an hour, the workers are being paid $13 an hour, and that's what it says right there on the pay stub. So that just makes the case easier to litigate. And if there were even more penalties, I think rather than lead to more litigation, I think that leads to less litigation, right? So if you know that your pay stub shows you did not pay correctly, you're going to be subjected to double or triple penalties. If you have a good lawyer on the employer side, they're going to tell you to settle that case. Let's resolve this. Let's start paying correctly, and then we won't face this again. One of the other things that's in the bill is also to codify the standard that if an employer doesn't keep records, that then the employee's testimony is presumptively true about their hours and their wages. And it's really important to get that in the statute, because I think that then employers will be on notice that, oh, it's good for me to give the pay stub, because then, I'm doing something right. We deal with things, immediately if they happen, and they realize that if they don't, what my workers comes in and testifies, it's going to be very difficult for me to rebut that. So I think a lot of the provisions will make it easier for employers to comply with the law, and will make it more likely that there will be early settlements rather than long litigation.
Young lady's time is expired. All right, thank you very much. Mr. Good, you are now recognized, sir. 5 minutes.
Thank you, Madam Chairman. Thank you to Ranking Member for holding this hearing. I want to thank our witness who's here, Ms. McCutcheon, for being with us in person. I suspect this will be a requirement of this and every other committee in a few months, and I appreciate your courageous example of being here with us in person. As you know, though, as we all know, we're experiencing record inflation in the country, thanks to the reckless and relentless spending sprees by this administration. This is further exacerbated by the Democrat COVID lockdowns that have decimated small businesses, many of which will never recover. In fact, the NFIB has reported that 25% of businesses, small businesses in my home state of Virginia, have closed permanently, never to reopen again as a result of these Democrat lockdowns. This is even more tragic when you consider the fact that some 90% of Americans work for small businesses, so we know who ultimately this is impacted by. They're not going to make any wage without a job. But we should be working, I know you agree, to get the heavy oppressive hand of government off the necks of working families and small businesses. Matter of fact, tomorrow I plan to introduce my bill, the Small Business Before Bureaucrats Act, which would update the 60-year-old NLRB regulatory standards to reduce the number of businesses that are under the oppressive control of the NLRB. It would increase by tenfold the standard for when a business would have to qualify to be under that control. But back to the 40-year high inflation rate that we're all suffering under, which I believe is the #1 issue for most Americans today. In the State of the Union address, this president made it clear that he blames business owners, or seemed to make that clear that he blames them. I don't know if he was dishonestly trying to deflect from his terrible record, his failed policies, or if he simply, after 50 years in government, does not understand what it takes to run a business, to operate at a profit, when he said to businesses, lower your costs, not recognizing that businesses every day try to do two things: increase revenue, reduce their costs so they can survive, meet their payroll, keep their employees or doors open, and employ their employees. Congress should be looking, I think you agree, to empower job creators to survive this economic crisis. So I ask you, what's the most important action, or some of the most important actions that you believe that Congress could take to empower job creators and hopefully therefore bolster the wages or the opportunities for working Americans?
Well, I think one of the most urgent things, just like your bill is going to be in the LRB, is exclude more small businesses from the FLSA coverage. It's 500,000 in annual business sales. It's been that way for decades and decades and decades. So taking that up by 10 times would be a help to get the federal government out of small businesses. But this bill would do the opposite effect, right? It would, yes, under this bill, even minor unintentional violations, the penalty is going to be $22,000 per violation per employee. Now think about that. You have 5 employees and you make a minor mistake on your pay stubs, that's $100,000 in fines a week. That is going to bankrupt small businesses, and it just can't happen in this economy. I will also say, I was at a conference last week where hospitality employers, the whole discussion was staffing, staffing, staffing. We cannot get employees. You've seen the health wanted signs on every store, on every restaurant. We need to simplify these rules so that employers can comply with them easily, pay the employees what they are owed now, not after 3 years of litigation.
Well said. I tell folks back home in the district, this Democrat majority looks with contempt and disdain at job creators, employers, business owners, and believes that they seek to exploit their employees. They must have done that to become successful and to be an employer to begin with, and continues to layer more and more consequence, punitive damages upon employers who are just trying to survive, just trying to pay their employees. Could you speak, with limited time that we have, that what you referenced the need for clear and simple labor rules. What should Congress do to more simplify and eliminate some of those to help small business owners?
Well, my written testimony actually has 10 ideas for FLSA reform that would help do that. That includes, for example, and refocus on low-wage workers. That includes excluding high-compensated workers from the coverage of the FLSA, make them exempt. It includes allowing businesses and employees to enter private waivers of claims so they can resolve issues quickly and privately without the danger of being sued again. I could go on and on, but we just need the regular rate. I'm sorry for the time, but today, to get staffing, businesses have to give special benefits and special pay. Like Dollywood, where I'm from in Eastern Tennessee, is giving full free college educations to every full-time and part-time employee from day one. Now, before the Trump administration regulations on the regular rate, that would have caused overtime liability, free meals, free health care. You can't give that without violating the FLSA.
Thank you very much.
Excuse me,
Thank you.
We've got to move on.
Thank you, Madam Chairman. I yield back.
Thank you. The gentleman from New Jersey, Representative Norcross, you are recognized, sir, for 5 minutes.
Thank you, Madam Chairwoman, and for holding this incredibly important hearing. I know what it's like to be cheated out of wages. Unfortunately, when I was a young man, I was the victim. And there is a difference between somebody making a mistake and what we're talking about today. And I will talk about this with one of our witnesses to get his feedback. I have never heard in my entire career of somebody going into bankruptcy, being prosecuted criminally because of an accidental mistake. The ones that we are talking about today are intentional, are large, and hurt real people. I understand contractors are the partners of workers. We're in this together. But there's a distinction between a good contractor who does the right thing and might make a mistake, and what we're going to hear here in a few minutes. Mr. Aspire, let's talk about the bad actors. And in your case, the wage theft, you joined with 200 plus other workers in a class action suit for $618,000. That's not an accidental mistake. Let's be clear. You're working for the employer. Talk to me about what kind of pay stubs, earnings statements that you received. How was it that you were either able to document or difficult to document the wage theft?
Sure. Well, the form of payment from this person that I was working for, he was just giving me a personal check with a certain amount of money for the hours that I worked. There was no overtime paid after 40 hours. I used to work from Monday to Sunday and still get paid the same amount for Saturday, Sunday. And I was keeping record of everything that I was doing because, like I said on my testimony, the union was educating me, and they told me to start saving those as proof.
So when you got a personal check, it was just made out to you, the amount and the signature by the employer?
Yes, that was it. There was no pay stub or anything, so it was just an amount, and that was pretty much.
Did that happen week after week, or was that a one-time occurrence?
It was week after week.
So this isn't an accident by any stretch of the imagination. And that's what I'm trying to suggest here to my colleagues. There's a huge difference trying to put little guys out of business. No, we're not. They're the ones who drive our country, the ones we work with. That's not an accident, folks. Oh, gee, I forgot my pay stub today. Okay, goes once. How many weeks did that happen on your job?
I want to say around probably 10 weeks straight.
Yeah, that's a pretty big accident. So when we look at what's going on, if you had a standard, what most people around the country have is how many hours you work, the amount of pay, that would have been very helpful in terms of making sure you got the right pay. Now, was it just you on the job that got that, or were there other workers?
Oh, there was multiple workers there.
Yeah.
Yeah.
And unfortunately, in the construction industry, these are some of the things that I ran into as a young apprentice, trying to make my way through the industry like you, Mr. Francisco. It is tough. And all we're doing is checks and balances. Nobody wants to get beat up here. We all want to have a shot at life, but we want a fair playing field. And the fact of the matter is, when they hold a hammer over some of the employees' heads like we're hearing here today, that's not that's not a level playing field. We all should be focused on getting rid of the bad actors and making sure that everybody plays by the same rules. Contractors don't go out of business for making a little mistake. They do not get criminally charged accidentally. It's bad actors, and I want to thank you for sharing your story, and I yield back the balance of my time.
Thank you very much, Mr. Norcross. I want to recognize Ms. Steele. You are recognized for 5 minutes.
Madam Chairwoman, thank you very much. Independent contractors and entrepreneurs and small businesses in my home state of California already understand the devastating effects California burdensome laws have had on their ability to provide for their families. There are more than 2 million independent contractors and entrepreneurs working across California. And now more than ever, we should be supporting our workforce and providing clear guidelines, give workers more flexibility and independence to find the right job for them. Those who choose to become an independent contractor want and enjoy the independence and flexibility and control that is provided to them. Recently, the court blocked the Biden administration attempt to limit clarity and guidance on the classification of contractors under the Fair Labor Standard Act. Having said that, Ms. McCutcheon, if I pronounce it wrong, sorry, with your background and knowledge of your Labor Department and recent court rulings, how is current department actually observing the independent contractor worker classification rule? And do you agree there should be more certainty for workers and employers?
Thank you for that question. Right now, there's actually no published regulations on independent contractor status. And that's a particularly tough situation because under federal and state law, there are actually over 100 different regulations and statutes which have independent contractor standards in them. So the Trump administration did the right thing in establishing a clear, simple rule that employers could follow. Right now, what we have at DOL is no rules at all. So it's litigation, it's setting the standards through litigation rather than legislation, and that is pretty tough, especially for small businesses, to figure out what is the law that they're supposed to be complying with.
Thank you for the answer. I'm very supportive of local small business models and empowering minority entrepreneurs to start their own business. And let me ask you one more question. With vague definitions of independent contractor classifications and joint employer, would this hurt those who want to open their small business under the franchise model at this point?
Well, it makes it very difficult, right? Most businesses, in my experience, want to comply. They want to do the right thing. but they're not compliance machines. When you're opening a small business, especially in today, you have enough problems just trying to open a small business, let alone having to try to figure out all these laws. And with this bill and the $22,000 per employee per violation for unintentional violations, that's ruinous for small businesses. And so I just don't know how, even if I was a small business owner, I would be scared today in trying to open a new business because I don't know how you survive this type of bill.
Especially California, it's much worse than any other states and nation. So thank you very much, Madam Chair, and I yield back.
Thank you very much. Let's see, I want to recognize Representative Stevens.
Yes, it's great. Hi.
You got 5 minutes, ma'am.
Yes, sounds good. I'm ready to rock. If surprised that all 5 minutes of questioning wouldn't be used by any member of Congress. The egregious topic at hand, noted as wage theft, preventing wage theft and requiring stolen wages, particularly in a time of rising costs, particularly in a time of inflation. I think we should be helping the American worker achieve and recuperate and gain all of the wages that they are owed. I really want to salute Mr. Esperanza for being here and for your testimony and for your effort. Certainly as a labor-aligned member of Congress hailing from the great state of Michigan, I represent Oakland County in the Congress, working alongside many building trades unions. I do want to express that we have our own challenge in Michigan as it pertains to prevailing wage, right? And making sure that prevailing wage continues to be the utilization and the method of how contracts going forward. And yet it was rolled back in Michigan, and I know our governor, Governor Whitmer, has been working to combat that. I know that here in the Congress, I am very dedicated to this effort, and I'm proud to be an original co-sponsor of the Wage Theft Prevention and Wage Recovery Act, a responsible solution to deter wage theft and help workers seek justice. I'm going to be clear. You're not on board with this. You're part of the problem. Okay. I'm a daughter of small business owners. I know I've seen my dad go through it with his landscape company, and he pays his workers for a good day work. So Mr. Swanson-Clark, Ms. McClutchin says that increased penalties for violating the Fair Labor Standards Act could harm small businesses. Please remind us, how many people do you employ?
I employ 20. I have 20 on staff.
So you consider yourself a small business?
I am a small business.
And do you think businesses of any size that play by the rules would have anything to worry about with the increased penalties in the Wage Theft Act?
I feel that I am in compliance with what is here. I am doing my best to match all of the requirements, and I have no fears of what's going forward.
Right. And we know as a result of ongoing pandemic, unbelievable and catastrophic war started by Russia in Ukraine. Prices are rising. People are going to the grocery store. They're paying through the roof for the brisket, the roast, the this and that. So could you please highlight, Mr. Swanson-Clark, how would you, some of the technical assistance and resources available to small businesses that they can use to be sure that they are compliant with wage and hour laws?
Now, within Minneapolis, we feel we're pretty fortunate. I have business associations. The city has a small business team. We have been able to work with our state's supported community development corporations. All of them provide technical assistance and mentors. I myself have served as a mentor for new and emerging entrepreneurs in my own neighborhood. It's available. We put it to use online and in person.
Well, and it's exciting. That's great. So, Ms. Case, thank you so much for being here and for your role at the New York State Office of the Attorney General. Considering that there are no penalties for record-keeping violations and no requirements to provide employees with pay stubs, employers currently have little legal incentive to maintain accurate records. How important are pay stubs and payroll records for pursuing wage theft cases?
Thank you for the question. Yes, I think as I've said earlier, it's essential, right? It's essential for workers to know what they're getting paid, to be able to deal with it immediately if there is a problem, and then it's essential for the lawyers if there needs to be a wage theft claim. So if you are litigating a claim, that is your first piece of evidence. Is there a pay stub? What does it say? And is it accurate? And if an employer is correctly paying their employees, it is their best defense. So it is really, it's essential for everyone and will make things much easier.
Yeah, excellent. Well, with that, 10 seconds remaining, the near full utilization of my 5 minutes. Thank you, Madam Chair, and I yield back.
And thank you very much. I want to yield now to Representative Stefanik. You are recognized, ma'am, 5 minutes. Is Representative Stefanik on? Is Representative Stefanik on? She is not. Okay, Representative Scott, are you on the platform?
I'm not on the platform. I'm in the hearing room.
Okay, Representative Scott, you are recognized. I want to recognize the gentleman of the full committee on Ed and Labor. You are recognized, sir. You have 5 minutes.
Thank you. Thank you. Thank all the witnesses for being with us. And I want to start with Ms. Kakasi. We've heard a lot about technical errors. How do we know that wage theft is actually taking place not as just technical errors, but intentional acts?
Yes, thank you for the question. I think it's by the volume, and I think that somebody recently just asked about this. If it is I forgot to give a pay stub one day, that's very different from I didn't pay wages to thousands of employees for years on end. So in the New York State Attorney General's office, we recently had a case that we resolved with two large agencies that provide home health aides. And there are two components to the settlement. One is over $5 million and the other is over $6 million. So this is for thousands of workers who were routinely not paid for all of the hours that they worked. So
We've heard a lot about errors that are made, people don't understand the rules and that kind of thing. How often do you see these errors benefiting the employees?
I don't think in the 20 years I have been in this field, I have ever seen one of those, but
okay, well,
people come to me when they have a problem.
Now, you mentioned recovery and mentioned the minimum wage on the FLSA. If you were promised $20 an hour and actually got paid $10 an hour, would you have any recovery available to you under the FLSA because you've been paid more than the federal minimum wage?
No, currently you would not.
You would not have a claim at all under the FLSA?
That's correct.
You would have a claim under contract, I'd imagine.
You could have a breach of contract under state law, but as I said earlier, that does not come with attorney's fees and it does not come with any liquidated damages. So it may be very difficult for you to find a lawyer to take that case.
So, and if it goes to arbitration, who pays the arbitration fees?
It is usually split between the employee and the employer.
So the employee would have to pay part of the arbitration fees? And if the claim is not a huge claim, you just got ripped off a couple $100,
it's certainly not worth it.
It's just not worth it. Now, are you familiar with the pending legislation?
Yes.
We've heard comments that the penalties are $20-some thousand up to and $100,000. Is that not to exceed those numbers?
Yes, of course, and the Department of Labor would have discretion if it was a small mistake not to award those high level of penalties.
And could they take into consideration the size of the business
Yes,
and how egregious the situation was?
yes.
Thank you. Ms. McCutcheon, you indicated that all states have pay stub requirements, is that right? Well, we can agree at least most states.
Yes.
Would it make sense for if you're operating in a lot of different states, you'd have a lot of different compliance. Would it make sense to have one federal law on pay stubs to preempt all of those different laws?
I think there's different viewpoints at that. I myself have sort of dreamed about writing a uniform code of employment law, but I think to do that would take a lot of study, right? Because you shouldn't automatically adopt what California and New York are doing, which are very burdensome and haven't had a great effect in those states. So you would want to study every single law and figure out what's the middle ground.
Well,
right? What is
you
most
would only have to learn one system. You wouldn't have to learn each and every one if you have in a number
Correct.
of different states.
Correct.
You also talked about tolling the statute of limitations during the investigation.
Yes.
And you think that statute of limitations should not be tolled?
That is because I am afraid that if you told the statute of limitations, there would be no incentive for the Wage and Hour Division to complete their investigations more quickly, and it is speed that low-wage workers need. They need to get their pay.
Of course, on the other side, the statute of limitations may expire while the investigation is going on, and the person waiting for action just lost his case.
Every day, right, is a new back wages. So it very rarely happens that you lose all claims. You still will have 2 or 3 years of back wages to collect. And I think, this committee in particular can conduct great oversight of the Wage and Hour Division to make sure they don't do that. They shouldn't do that.
Thank you, Madam Chair. You're back.
Thank you, Chairman Scott. We appreciate you being here and your test. And I want to just thank all of the witnesses. I don't think there are any other members present, at least that's the information I have. So let me thank all of the witnesses for their participation today. Members of the subcommittee may have some additional questions for you, and we ask the witnesses to please respond to those questions in writing. The hearing record will be held open for 14 days in order to receive those responses. I do want to remind my colleagues that pursuant to committee practice, witness questions for the hearing record must be submitted to the majority committee staff or committee clerk within 7 days. The questions submitted must address the subject matter of the hearing. I want to recognize the distinguished ranking member now for a closing statement.
Thank you. As we've heard throughout today's hearing, Republicans and Democrats share a common goal in ensuring that workers are paid in full for their work as required under the Fair Labor Standards Act. Unfortunately, Democrats are advancing a partisan proposal which will fail to meet that goal. Instead, the DeLauro bill will add to the challenges job creators and American workers are already facing in our struggling economy. The bill's gotcha-style treatment of unintentional or technical violations of the FLSA, combined with its disproportionate penalties, will have a chilling impact on employers. In addition, the DeLauro bill drastically expands the authority of the Department of Labor's Wage and Hour Division, requiring the agency to enforce all pay-related contracts and collective bargaining agreements, interfering with its core mission of enforcing federal wage and hour requirements. Workers and employers both benefit from clear and concise rules, but this bill is a step in the wrong direction. A supply chain crisis and rising inflation are already wreaking havoc on our economy. This legislation, if signed into law, could be the nail in the coffin for many struggling job creators. The DeLauro bill is counterproductive and will harm America's job creators and workers. These economic engines deserve better, and I urge my colleagues across the aisle to promote bipartisan solutions that ensure collaboration among the Department of Labor, employers, and workers. I'd like to thank our witnesses again for participating in today's hearing, and I yield back.
Thank you, Ranking Member Keller. I want to thank our witnesses for being here today. Today, our witnesses underscored the pervasive and severe consequences that wage theft has on our workforce. Every day, workers across the nation keep our communities running and economy growing. Unfortunately, unscrupulous employers stiff their workers out of the wages they have earned. Again, we want to raise people, if we want to raise people out of poverty, if we want to ensure that Americans have the opportunity to enter the middle class, and if we believe that workers deserve a decent wage for an honest day's work, then we must enact a meaningful deterrent to wage theft and help workers seek justice. To do so, Congress must pass the Wage Theft Prevention and Wage Recovery Act, and finally ensure that wage theft is no longer profitable for dishonest employers. So thank you again to our witnesses for your time and your testimony. If there's no further business, without objection, the subcommittee stands adjourned.